We're calling the case of People versus Robert Durst. Mr. Durst is not present. The court has allowed him to appear through his attorneys pursuant to 977B of the Penal Code. He executed a written waiver. I'm allowing counsel to appear telephonically. And may I have your appearances, please?
John Lewin.
Good morning, Your Honor. David Chesnoff, Dick DeGuerin, Chip Lewis, and Donald Ray on behalf of Mr. Durst.
Thank you. And now Mr. Lewin.
John Lewin for the people, Your Honor. I know that Mr. Baleen is on the call with the defense. And we've also got Eugene Miata, Ethan Milius, Tim Henderson, and then we have two investigating officers, Detective Elizabeth Camacho and Detective George Shamlian.
We're having difficulty hearing Mr. Lewin.
Okay, I'll shout louder. Is that better, Dick?
That's better.
Okay.
All right, we're here for several motions. The motions were scheduled for an earlier date, but were continued until today's date due to the presiding judge's COVID-19 emergency order. The courthouse was closed until today's date, actually until yesterday, and today was the first day all counsel were available. So the first order of business is the defense motion for a mistrial, which both sides have briefed quite elaborately. Do you have anything to add to your written argument, Mr. DeGuerin?
Your Honor, Dick DeGuerin, Mr. Chesnoff will take the leading role on this.
Your Honor, thank you. Yes, we do, and some may sound repetitive, Your Honor, but we need to make a very complete record on this in light of the unprecedented nature of the issue. So if the court would allow me to proceed.
You may proceed, Mr. Chesnoff.
Thank you. If it pleases the court, it's respectfully submitted that the primary reason the people oppose the request for mistrial is the time it would take to pick a new jury. We remind this honorable court of the language from Stanley v. Illinois, 405 U.S. 645, that a lawyer colleague of mine reminded me of after our brief was completed. It's a United States Supreme Court case, and it says, the Constitution recognizes higher values than speed and efficiency. Indeed, one might fairly say of the Bill of Rights in general, and the Due Process Clause in particular, that they were designed to protect the fragile values of a vulnerable citizenry from the overbearing concern for efficiency and efficacy. And as stated by the California Supreme Court and Williams v. Superior Court, quite simply, the pursuit of judicial economy and efficiency may never be used to deny a defendant his right to a fair trial, which of course is the holding in Ayala with the standard for determining whether a mistrial is appropriate. Your Honor, no California court has ever approved a mid-trial delay exceeding 37 days, not requiring this case to start over. If we were to begin July 27, 2020, that would be 135 days from March 12th. The people concede that there is no applicable judicial precedent for resuming a trial with the same jurors after a delay of this magnitude. Should we reconvene, the state further concedes that after this surging first wave, which I would note, according to the records of today, Los Angeles smashed their previous high for COVID infections by 20%. So assuming we're in the first wave and it's surging, a second wave would hit while we are resumed, causing another adjournment. While the people go to great lengths to draw distinctions between the present facts and several cases we cited, they fail to accept the fact that the case we cited are logically reasoned on the dual risks inherent in mid-trial interruption, that being the fading of memory or confusion as to testimony heard by the jury, and secondly, the prolonged exposure of jurors to outside influences. This is not intended to impugn the jurors, Your Honor, but it would be blindness to social reality not to believe that in such a highly publicized case, outside influences exist to which even the most conscientious juror may have been exposed to. They have not, to our knowledge, received regular admonishments, nor have they been polled. Just this weekend, Your Honor, CNN had a TV commercial for a show entitled Very Scary People, which will highlight Charles Manson, Gacy, the Zodiac Killer, the Night Stalker, the BTK Killer, and last but not least, Robert Durst.
Mr. Chesnoff, I'm going to interrupt you, Mr. Chesnoff. The jurors have now received 3 admonitions after the final admonition. They're admonished again.
Most respectfully, Your Honor, we were not aware of that, and we appreciate your telling us, but it's still, as the cases state, and as I will talk about in a few moments, the courts recognize, as much as you would like to believe that they're going to follow the admonition, when they're at home for this period of time, the courts have all found that you don't have to show actual prejudice. The fact remains that there's a presumption that they have been exposed. The state makes much of the fact that several of our cases describe requests for a continuance rather than motions for mistrial. But that is a distinction without merit, Your Honor. The people fail to appreciate that those cases are predicated upon our highest court's unequivocal belief that a 2-month hiatus, less than half of our situation, would and does create an impermissible risk of exposure to outside influences, and to the real concern, regardless of good intentions of the juror or the court, that memory fades as to the evidence heard. Equally unconvincing and undeniable, in spite of the state's gratuitous comment that it is laughable, is the people's suggestion that the lack of justification in the Santa Maria case for an adjournment is comparable to the instant case. We agree that COVID-19 provides a far more compelling reason to mistry our case and to start all over. As Santa Maria held, the longer the separation, the greater risk of outside influences. That case held that an 11-day continuance, which was granted, far exceeded the limit of experience and reason, and most importantly, the due process right of the defendant. After all, an unprecedented delay involves as a matter of law the reality that prejudice will result, and Mr. Durst will be denied due process. The people can't distinguish the authorities we cited other than to say some dealt with continuances as opposed to mistrials. More significantly, they have wholly failed to cite a single case saying a delay of 135 days should not be a mistrial. Not one reported decision in the annals of recorded American jurisprudence. The defendant is not asking for a do-over, Your Honor, just a fair and fresh start. Since the people argue that what has occurred up to now is just a snippet of the trial, the only time issue will be in selecting a new jury, and that is a small price to pay, Your Honor, to ensure that Mr. Durst receives a fair trial. Mr. Sabelli of the MACDL has provided the court with a declaration relating to the reality of time constraints or the use of time in the LA County jails, which I believe would be helpful to the court, and he is certainly a person of merit and note. We are also concerned, Your Honor, with the health of all involved. The jurors, your staff, the DAs, and the defense team. The spectators who may get into the courtroom if there's enough room. With respect to jurors, the press, for that matter. With respect to jurors, we don't know which jurors have been exposed to COVID, which one of their friends or relatives have been exposed, which jurors have lost their jobs, which jurors need now to work even more, which jurors have child care issues compounded by COVID. We provided the court with a questionnaire in our papers based on a Contra County questionnaire which led to a mistrial. We have provided the court with this questionnaire and we welcome its circulation to the jury. We are very concerned about the attitudes jurors might have against Mr. Durst, who they would perceive as compelling their presence in the face of COVID, which is of course exacerbated by the immense prejudice which already exists in our case because of all the information the jurors have about Galveston, for example, and dismemberment, and the early witnesses talk about Mr. Durst's domestic violence. Jurors are not only concerned with dying from COVID, Your Honor. COVID causes immense pain. And I recently heard where a person described it as if they had an elephant sitting on their chest. We're not just talking about dying, we're talking about people getting sick. In addition, Your Honor, they keep telling us that, well, it's the old people. Well, the truth of the matter is, if you told a parent of a young person that died of this, that they're the exception, that young person still died. And I don't think anybody is really accepting the gravity and the consequences of being placed in an environment that is still unsafe, as attested to by our doctor, who is from UCLA and has spent his entire career working with respect to infectious disease. In addition, COVID causes lifetime medical issues if you recover. So the argument that it may not kill you doesn't take away from the fact that we are dealing with a circumstance that causes everybody connected with this case to be potentially harmed, their families harmed, wives harmed, children harmed. It's not, that's where we're at, Your Honor, through no fault of anybody, except I do place some blame on our government, but that's for a later part of my argument. Assuming our jurors would naturally have COVID concerns, and most respectfully our own infectious disease expert, Dr. Klein, believes that as well-intentioned, Your Honor, as the court's efforts in Inglewood reflect, it is not safe. What social distancing is our jurors or other participants doing when they're not in court? Are people wearing masks when they're not in court? There's been no, which your governor now insists that people do. There has been no independent medical certification that our lengthy trial can continue safely, as the NACDL strongly recommended in their report. Will we be able to fully maintain social distancing when we're in court? Will there be social distancing in the hallway, in the cafeteria, in the elevators? Our present jury has not even been time qualified again, Your Honor, for 4 or 5 more months. 4 jurors have school-age children. What child care arrangements will they need to make in light of the COVID? 3 jurors are healthcare professionals, all working at VA hospitals. What has been their exposure experience since the outbreak started? 5 jurors are over 65, 7 more over 50. We provided the court with other courts that have declared mistrials. One was particularly telling. In Colorado, District Court Judge Mark Warner noted that prospective jurors broke down and cried because of their fear of COVID. In Fresno, the DA himself moved for the mistrial. Now, Your Honor, I want to talk about another very important rationale for granting a mistrial and setting this case when it's safe. The right to counsel. The right to counsel guaranteed by the 6th Amendment is directly impacted by proceeding when 3 of Mr. Durst's lawyers have all been advised by their personal physicians not to resume the trial until medically appropriate. Your Honor, please let me emphasize, Mr. DeGuerin, Mr. Ray, and I have all dedicated our entire careers to helping citizens accused of crime. We take it as seriously as any lawyers that I know. We have never abandoned a client. We want to try this case. We want to finish this case. Mr. DeGuerin's relationship with Mr. Durst goes back decades. After all, it's Mr. DeGuerin and Mr. Lewis who got him acquitted previously. If that doesn't engender confidence in a lawyer, nothing else should. Nothing else can. It's Mr. DeGuerin who also told our jury that Mr. Durst would testify. And it is Mr. DeGuerin who took on the responsibility as our lead counsel to prepare Mr. Durst to do so. At this time, that function is an impossibility. Mr. DeGuerin cannot leave Houston. Houston is having a huge surge right now. He is not traveling. His doctors told him he can't. Besides which, the hours at the Twin Towers have now been dramatically changed. It's just it's impossible for real 6th Amendment effective assistance of counsel to be rendered. Mr. DeGuerin, as a result, can't keep his promise to the jury to put Mr. Durst on. Now, Your Honor, to suggest that Mr. Durst will remain in federal custody until March 2021 and will not receive bail in this special circumstances case, will not be available for trial when it is safe, is unreasonable. Of course he'll be there. I have represented Mr. Durst for 5 years, including in New Orleans, and have a very close attorney-client relationship with him. I have a trust with him, and he has a trust in me. The same applies to Mr. Ray, who's been his LA lawyer since even before he arrived in California. Chip Lewis has a decades-long relationship with Mr. Durst, but also has had health issues which could be implicated by COVID. The court has indicated it would not jeopardize our respective hopes or health by requiring us to attend. But where would that kind gesture, which we truly appreciate, Your Honor, leave us? 3 lawyers who want to finish the case would not be able to, and Mr. Durst would suffer the consequences. Mr. Lewis cannot try this case by himself. My associate, Mr. DeMarco, who has assisted me ably in this case, is a wonderful researcher and writer, but his trial experience is very limited. Ms. Bain, for personal reasons, has informed Mr. DeGuerin she is not and has not participated in the trial and does not intend to do so moving forward. The witnesses have been assigned to each of the 4 primary lawyers, and Mr. DeGuerin has been assigned Mr. Durst's testimony. I've been assigned Dr. Loftus. In U.S. v. Gonzalez-Lopez, the United States Supreme Court clearly stated that one element of the Sixth Amendment is the right to counsel of choice. Mr. Durst has chosen lawyers that have been with him for many, many years. He is therefore constitutionally entitled to them. This honorable court has commented on our abilities, and we have all appreciated your belief in our skills, and therefore reiterate that Bob Durst should not lose his counsel of choice because of a vile disease. The court also has Mr. Lewin as a prosecutor, whose skill and talent Mr. Durst deserves lawyers he believes are up to the challenge of such a worthy adversary as Mr. Lewin and his team. Your Honor, patience will lead to a safe resumption of this prosecution and of this defense. Where there is an erroneous deprivation of the right to counsel of choice, the result is reversal, with no additional showing of prejudice. In other words, why not grant a mistrial and avoid a trial that would be reversed if Mr. Durst's 3 lawyers aren't present? Certainly, Your Honor, that is not judicial economy. Mr. Sabelli's thoughtful and thorough declaration comes from an advocate whose sole mission as a lawyer is to see justice done for defendants worldwide. His declaration includes the detailed report from the NACBL, the most highly respected organization guaranteeing people accused of crime of their constitutional protections. It is clear from those 2 exemplary sources that a trial of Mr. Durst's counsel of choice would be affront to everyone's constitutional rights guaranteed by the Sixth Amendment, and the NACBL and Mr. Sabelli have taken an interest in this case because it is of national interest, because it is the Durst case. Assuming arguendo that the court did start again before it's medically safe, Mr. Durst, who is hard of hearing, will be 6 feet away an arbitrary distance for alleged safety from counsel and will not be able to effectively communicate with his lawyers. Mr. Durst suffered from esophageal cancer, cervical spine stenosis, hydrocephalitis, chronic urinary tract infections and blockage, chronic lower gastrointestinal dysfunction. He presently now has a growth in his bowel, and he suffers from chronic fatigue. Actually, the reason that Mr. Durst has not gotten COVID is because of his isolation. It would be ironic that moving him from the jail where they have him in complete isolation to a courthouse where he could contract it, it would be ironic that he spent all of his time avoiding a disease only to be impacted by it because of a rush back to trial. Mask wearing, Your Honor, will distort the normal trial process. According to Governor Newsom's directive, witnesses will not have to wear masks. Witnesses whose facial expressions will not be seen by the trier of fact, nor will they be seen by Mr. Durst. And as Justice Scalia wrote, historically, one of the most important parts of confrontation is the right of the person being accused to face his accuser. The dangers in elevators, restrooms, and cafeterias are real, and the out-of-state counsel are going to be having to live in hotels which themselves are under severe restrictions. I just read in the New York Times yesterday, Your Honor, Chief Judge Kathie McCormack of the New York Southern District just stated that jury trials cannot start for months. They are well down the road. And, quote, you can't put masks on witnesses in a criminal trial because the defendant has a right to see them. Your Honor, in spite of the historical warnings from experts that a COVID-19 pandemic could occur, or something like COVID, our leaders on both the state and federal level were grossly unprepared for the ensuing sad reality of sickness and death we have witnessed. There is no vaccine, it is highly communicable, and unfortunately it is silently transmitted even from people not exhibiting symptoms. There is a present spike in phase 1, due in part to early reopenings and to the protests in our streets. Regardless of the necessary message of the protesters, both the decision to prematurely reopen and the protests were well-intentioned, just as finding a large courtroom with safety steps is well-intentioned. But no amount of precautions can stop a disease with no cure. The defendant is highly vulnerable. Jurors who fit the category of over 65 are vulnerable, but so are the relatives of those over 65 or under 65 of jurors who may sit and be exposed, as are the 3 lawyers who no one can question want to be zealous advocates wishing to represent Mr. Durst. All we are asking, Your Honor, is that we try the case with a jury not affected in any way with the lawyers Mr. Durst chose that are not affected by this horrible disease, and that a just verdict follow. A few extra months out of our lives to pick a new jury will ensure many, many more months of life for all of us. You, Your Honor, the staff, the law enforcement people involved, Mr. Lewin and his team, Mr. Durst and his team, all the people affected by this trial. We ask you most respectfully, Your Honor, to grant a mistrial because that is the prudent and appropriate constitutional decision to make. Thank you for listening to me, Your Honor.
Thank you, Mr. Chesnoff. Mr. Lewin, you may address the court.
Your Honor, there are 2 ways that I can go about this. Mr. Chesnoff raised many issues that are a repeat of what he has in his motions. He also introduced some new ones today. My first question to the court, Your Honor, if the court is willing, and again, this is for the court and counsel's purposes rather really than my own. If the court at this point is inclined to not grant the motion, to deny it, then I'm going to be much more brief in my statements. The only reason I'm going to respond at all is because although I do not believe this is writable, it is certainly, and the court's nodding his head, I think the court agrees with me on that premise. Is that correct, Your Honor?
Yes, Mr. Lewin.
But in the event, because things are so different, I want to make sure that I do respond briefly to some of the things he has said. So I would ask the court, Your Honor, again, I'm merely asking to save the court some time. If the court is inclined to deny the motion, I'm going to be much more brief because we've laid it all out in our motion.
No, I thought your response was comprehensive, but if you choose to add to it, you may at this time.
Okay. Then, Your Honor, I understand I'm going to have to then address it. It won't take as long as Mr. Chesnoff, but I need to make sure that I do my job and that I represent the people as zealously as Mr. Chesnoff is representing Mr. Durst. So first of all, a couple of issues. Number one, the standard is not as Mr. Chesnoff has described it. Now, he wrote it properly, but they have the burden to prove that the defendant will suffer irreparable damage. And as the court is aware, and that comes from the case they cited, Cal Supreme Court in Iowa, it says, as such, a showing typically requires some logical, tangible showing of prejudice to the party seeking the mistrial. So that's number one. Number two, and this is concerning. Now, I don't know if Mr. Chesnoff just slipped up, but when you tell a court, as he said, that, quote, prejudice can be presumed, that is an absolute misstatement of the law. And the idea that counsel would make that argument when there's no authority to support it and then throw it in an oral argument, Your Honor, it's either gross negligence or it's misconduct.
I didn't take it as a legal argument. I took it as a description of the nature of things, a tendency for people to be curious about what's on the media. But I think that I'm really governed by the California Supreme Court's repeated ruling that the jurors are presumed to follow the instructions that I have given them. And that's why the court's gone to great length. But recognizing this problem, the court has each month reminded the jurors that they are not to follow media accounts, nor are they to discuss the case with anyone.
The next issue, and counsel brought this up, is counsel basically says to the court, listen, if you don't grant this, you're going to be reversed. The standard is an abuse of discretion. And let's look at this for a moment. Every argument that counsel makes would apply to every other trial that is out there in the state and nation. So if you look at the arguments that they're making, if that were true, then the Chief Justice and the presiding justice of the county would have said to the court, Judge Wyndham, you are to grant a mistrial in this case. We are to start over. We will not be continuing with any trials. That is not what the order was. So by definition, counsel's arguments are simply unsupported legally because there has been no such dictate by the Cal Supreme Court, and they certainly were in a position, they made very clear, what they said was, let's try to look at ways that we can continue on with these trials and what modifications can be made. So that's the second point. Now we get to kind of the nuts and bolts of what counsel is really arguing. And when you look at what their position is in the case, Your Honor, they basically are saying that in essence, it's impossible for him to receive a fair trial, and they cite to the fact that, quote, it is unrealistic to expect the jury to remember the evidence it received prior to the adjournment and avoid outside influences during a delay of this magnitude. Now, let's examine those one at a time, because they're disingenuous, and they're factually inaccurate, and they're just simply not true. Let's go with the first one. We've had a total of 10 witnesses testify over 2 days. There are 20 different ways that the court could resolve this situation, which the court is required to do short of mistrial. Among them, they could have the testimony read back. They could have the witnesses recalled. We actually had audio tape of each of the witnesses who testified. The court could inquire of the jury if there's an issue with them remembering the testimony. But here's what's really an interesting concept to kind of analyze. The things that these witnesses testified to. Number one, Your Honor, they're not in dispute. These witnesses testified to Kathie Durst's upbringing, not in dispute. They testified to the domestic violence, not in dispute. When I say not in dispute, not only not in legitimate dispute, the defendant has admitted repeatedly on tape and even during jury selection that, in fact, this is conduct that he engaged in. Number three, and the only other witnesses who testified, were the witnesses that went to the finding of Susan Berman's body. And as the court's aware, none of that is in dispute. There was limited cross-examination. Then you have the fourth point, which is really, again, it takes some nerve. The defense says, hey, listen, we're concerned the jury can't remember this evidence that, one, is damaging to our client, and two, which is not in dispute. So I think, Your Honor, and this is why it becomes very important, previously, and in our motion, we attached, Your Honor, as the court is aware, a summary of a conversation that the defendant had with his wife back on March 24th of 2020. And Your Honor, so again, Your Honor, the court had asked, and we had agreed, So I'm not going to, at this point, Your Honor, repeat the specific comment that the court did not want uttered. But what I will address is the fact that Mr. Durst, in that conversation, made it clear that he wants a do-over. This is a tactical and strategic point. I know the court had said on our conversation with the defense, which was not transcribed by the court reporter, that, you know what, to some degree the court is looking at just a legal issue and it doesn't matter what Mr. Durst wants, etc. And Your Honor, certainly the court is free to look at that evidence and say, I don't give it much value. We have a different perspective, and this is our perspective. The defense in this case, Your Honor, has asked for mistrials every day of the trial, and most days they've asked for mistrials 3, 4, 5 times. They've asked for mistrials, as the court is aware, on a variety of issues. At least 5 that I can think of, none of which had anything to do with COVID. So I think, Your Honor, we have to be realistic, and we have to go back and say, okay, is the COVID situation a legitimate issue? Absolutely. It is completely legitimate. But for the defense to get up and say to the court, Your Honor, we want to pursue on with this case. We've always wanted to proceed with this case. No, they don't. They've made mistrial motion after mistrial motion. So that's just not accurate. It's not correct. And the court can certainly, Your Honor, and this is important to us, Mr. Durst is a very wealthy man with a lot of lawyers. That's his right. It's his money. He can do what he wants with it. But he doesn't get his own sense of justice. He doesn't get his own process of justice, which is different from everyone else. He doesn't get a do-over because he's not happy with whatever issues he's not happy about, which the court's well aware of what those are. So I think when we're looking at the arguments the defense makes, we cannot dismiss the idea that in the end, this is gamesmanship on the part of Mr. Durst. And in the end, Your Honor, although he has attorneys, Mr. Durst is responsible. Ultimately, it's his case. These are his decisions. And Mr. Durst has made clear the decision he wants is, I want a do-over. So now we start looking at the other points that the defense makes in their arguments. They discuss the idea that the jurors are going to be susceptible to having committed misconduct by, quote, outside information. You know what's interesting, Your Honor? They don't cite to one piece of outside information that has been in the media that has not already been ruled admissible in this trial. So it's a very interesting point. Even if you assume that the jury disregarded the court's instructions, which we have no reason to believe occurred, the court has already let in all of the evidence that we have sought. It's all in. So the defense, the reason they don't come up, Your Honor, and I'll just give an example. Let's assume we had a case where there was a confession that had been kept out of the trial. And over an adjournment of the case, that confession was discussed in the media, and the jurors heard about it, and they were not able to disregard it. We don't have that situation here.
I think the only risk would be the tone of commentary about the evidence, because you're right about there not being any evidence. All relevant evidence is admissible, and I've admitted it.
Right.
So that's not really the point. And you're right, no examples have been given. The defense has volunteered to file such a thing, but again, it's not been identified for the purpose of this motion.
We also, Your Honor, in that same context, the conduct of Mr. Durst, which the defense even voir dired on themselves, which they chose to explain to the jury in the questionnaire. A CNN ad for some TV show that equates the defendant, I guess by implication, with these other notorious individuals. I don't know how that's any more damning than the defendant's own admitted and relevant conduct in this case. So I'm going to leave that, and I'm going to go to the next issue. The defense is now saying, and we're concerned, as the court's aware, prior to the defense opening, we went in on the record, and I said to the court and to defense, Your Honor, if they tell a story in opening that involves Mr. Durst having to testify, and they make the decision later, for whatever reason, that he is not going to testify, then I'm going to end up, in essence, jamming that story right back at them and explaining to the jury, you can't consider it. The court completely, and within the court's authority, and correctly said, listen, I can't stop the defense from, they have every right to present their theory. But you mentioned to them at that time, defense, if you choose to do that, Mr. Lewin's right. So you better be 100% sure he's going to testify. Now, what's also very interesting is that the defense filed, there's a declaration by Mr. DeGuerin that goes to the fact that he was Mr. Durst's chosen lawyer, etc. And what's very interesting about that, Your Honor, is they omit an incredibly important detail in that declaration, which I know the court is aware of, and that information is as follows. As the court remembers, the people had wanted to start this case for more than a year, between 1 and 2 years before we started the trial. It was defense continuances, and the people were, I think the court would agree, as patient and accommodating as we could possibly be. As we were about to start the trial, on October 28, 2019, Mr. DeGuerin brought up an issue of a health issue that he had and asked to continue the case for 6 months. The court said he wasn't going to do that, and the court said, in fact, that there was no guarantee that even if the court did that, that the problem wouldn't occur in 6 months. The court instructed defense counsel and all of us, this is off the record in chambers. I made the comment as follows, Your Honor, at this time, if the court delays this at all, as long as there's one lawyer available for each side, we're going through with this, correct? The court said that's correct, and defense counsel agreed to it. So now, what we have is Mr. DeGuerin is now saying, you know what, I can't continue for health reasons. But Your Honor, the defense already waived, and Mr. Durst directly waived that issue. The court said very clearly, Mr. DeGuerin, if you choose to start this trial and you're unable to continue with it, then that's a risk that you and Mr. Durst and the defense are taking. So now what Mr. DeGuerin has conveniently done is he said, listen, I can't proceed now for a different health reason. But that doesn't matter. They were already told, it was already explained to them, that in the end, one lawyer each, for the years and years that justice has been waiting to happen on this case, we're going through it. When counsel says one lawyer couldn't handle this case, they've had 5 years of discovery on this case. 5 years. They've been here since, in November, it'll be 4 years since Mr. Durst came. The issues are what the issues are. There is, at this point in time, Your Honor, it is not going to be acceptable for the defense to basically get notes from their doctors saying, listen, they can't come, they can't come to school today. It's, here's a note, signed my doctor. That doesn't work. It especially doesn't work in the context of all the efforts they have made to get the do-over they so desire. We are sympathetic, Your Honor, to the issues involving COVID. And I'll tell you what's another clue, Your Honor, as to where the defense is coming from. If the court remembers, back before we adjourned, I brought up the issue to the court of using two-way communication. I filed a motion at that point in time. I brought up using Zoom not just for the utilization of witnesses, but I actually brought it up back in March in case we ended up restarting the trial and we had to adjourn again. The people have made numerous efforts to locate and figure out different systems that can be utilized where communication is available between the attorneys, between the client and the attorney, etc. Mr. Milius sent a detailed email to the court and to counsel with all of these suggestions. The defense responded with, not only have they done nothing, there's been no evidence that they've made one call, made any effort. So they say, we can't prepare our client, Bob Durst, for trial. Really? You made the decision he was going to testify well before trial. As soon as they stipulated on December 22nd of 2019 that Bob Durst, in fact, wrote the cadaver note, Bob Durst was testifying. They didn't have a choice. They have to explain what the situation was. How many times do they sit down and prep him? Do they meet with him? Where are the letters that they have sent to LA County Jail saying, you know what, can you please help us? How can we meet with our client? Can we do it by video? Can you secure a room? Nothing. And the reason is very clear. This is not a situation of the defense as they present it, Your Honor. We so much want to go forward. We would do anything to finish this trial. We're as disappointed as anybody. That's not accurate. There's a word for it. I can't say it in court, but it's very clear, exactly, Your Honor, that's not sincere. They want a mistrial. I understand why they want a mistrial. I'm not faulting them for it. But my job as an advocate is to basically look at their arguments and see, number one, not only are they reasonable, but are they honest? And in the end, Your Honor, this desire for a mistrial, it pre-existed the pandemic. It's continuing with the pandemic, and when the pandemic is over, guaranteed, we'll be getting more mistrial motions because they want to start this case from scratch. So, let me just take a look, Your Honor. I think that I have covered, but I want to make sure. One moment, please. The last couple of things. Defense counsel talks about the issues of Mr. Durst and his health, etc. Have they inquired on whether Mr. Durst can be transported in his own van here? Meaning, can they just take him by himself? Have they even made those efforts? I don't believe they have. They're now talking about, well, what about the issues of individuals touching things? Well, Mr. Chesnoff wants to cite his current COVID knowledge. It's been very clear that all the experts are now saying that the way you get COVID is you get it by having extended contact with somebody for an extended period of time without social distancing, without a mask. The whole idea of touching something and then getting COVID has been disproved by the science. We also have the idea, and again they have proposed this, that in essence there's no way for them to get here because they can't fly. This was in the motions. They have plenty of time. They're being paid a lot of money on this case. They can find a way. Mr. Chesnoff's in Las Vegas. He can get here. Mr. Lewis is in Texas. He can get here. In the end, Your Honor, this comes down to really one point, and I know the court's aware of it. They have the burden of proving, in this case, that Mr. Durst has been irreparably damaged. They haven't even come close to proving that. In fact, the evidence that we put on has established it the other way, which is not even our burden. So, in the end, Your Honor, if this case is not done now, and the defense, this is yet another argument that I don't think they can actually believe, we're going to lose, quote, a few months of picking a jury. Are you kidding? There is not one jury, Your Honor, if the court remembers, who wanted to be on this case. Oh, and the defense wants to give our current jurors, they want to give them this questionnaire which can only be summarized as, let me suggest to you all the check boxes you can make so that you get out of jury service. If we waited to do trials like this to have jurors who wanted to be here, Your Honor, we wouldn't try any cases. So in the end, if we have to redo this, and I know the court had said to counsel and to the people on one of our phone conferences, we made the point, which is true and the court agreed with, if this trial is not done now, when are we ever going to be in a position where we're going to be able to get 400 plus jurors in the room to fill out questionnaires? How are you going to voir dire these individuals? How are we going to assemble them? Right now we have 23 jurors and we can distance. The court has worked very hard. So unlike the defense, who basically has said, hey, well, I guess, what can we do? Better mistry this thing. The court has worked hard, and the people have worked hard to try to find and suggest alternatives. The court went and found a courtroom. I know that wasn't easy, Your Honor. I know the court was dealing with all kinds of responsibilities here, and you went out and you found us a courtroom, and you found a way to make this case work. So, in the end, Your Honor, they simply have not met their burden. And our concern is that Mr. Durst not be treated differently than any other defendant in Los Angeles County. He's not special. With that, we would submit it.
Thank you. Now, Mr. Chesnoff, you may reply to the new arguments that you've heard from Mr. Lewin, the ones that were not.
It reminded me of when I was a kid, and when someone was arguing with me, they couldn't answer the question, so they called names. I want to tell you this, Your Honor. He fails to reply to the arguments of all the courts that have said that even half as much time is the basis for a mistrial. All of those cases that we cited talk about the fact that judges across the board, federal judges, state judges, California judges, all recognize that if so much time passes during an adjournment, for whatever the cause of the adjournment, there is prejudice to the defendant, and that's why those cases did not start it over, either through reversals or mistrials. Mr. Lewin is unable to cite a single authority that says that you can have a 135-day delay through no fault of the defendant and allow that trial to resume again with the same jurors. Not a single case has ever said that. Secondly, this is not a fight between Mr. Lewin and Mr. Durst. This is the people of California against Mr. Durst, who has chosen lawyers. We do not make mistrial motions, Your Honor, for the heck of it. As the court knows from your own experience as a defense lawyer, mistrial motions are made based on the need for defense counsel to preserve the record and to ask for mistrials to start the case afresh without prejudice to the defendant. In this case, Your Honor, we represent to you, we want a mistrial because we believe, as the cases have held, that you cannot adjourn for this period of time and begin with the same jurors because of the two things that affect the jurors, their memory, Your Honor, as we talked about, and outside influences. Regardless of whether there's empirical data or not, those cases that we cite do not describe empirical data. They say it is a social reality that people away from their jury responsibility are affected by outside influences. Finally, Your Honor, not finally, in respect to this mistrial argument, we make this mistrial argument because it is righteous. The NACDL backed us, the strike force, because they made a conscious decision that it was righteous. It has nothing to do with Mr. Durst. If Mr. Durst had said he didn't want a mistrial, David Chesnoff, Dick DeGuerin, Don Ray, and Chip Lewis would have asked for one because that's what the law mandates, Your Honor. It mandates a mistrial in this circumstance. For Mr. Lewin to cavalierly describe Lewin on COVID when 120,000 Americans have died, it's not flippant, Your Honor. His argument was flippant. His disregard for scientific evidence, for example, contained in our pleadings, where the professor and doctor explained the comparison between a courtroom and the example that she gave in Korea. This is science. This reminds me of the idiocy of people who put in place controls who are now saying it's okay to have political rallies without masks on. That's the same kind of argument that is being made, which is causing the spike, which is causing more illness, which is causing more death. I cannot tell you, Your Honor, how in the big scheme of American jurisprudence, taking an extra 2 months to pick a new jury that hasn't been impacted, and for Mr. Lewin to suggest, what does he think Anybody in their right mind that was on a jury is going to want to come to a courtroom? He suggests that we are leading them to this decision. If, for some reason, Your Honor, you do not grant this mistrial immediately based on what's been put before you, at a minimum, Your Honor, you should inquire of these jurors as to the questions that were in that questionnaire, which ultimately, as we expressed, Your Honor, led to a mistrial in another case with another similarly situated judge. It just seems to me, Your Honor, that the most important thing is Mr. Lewin cannot cite any authority that says Mr. Durst should have to go to trial with a jury that's been gone for 135 days without his lawyers. He doesn't address that. And when we said, even though he went and divulged something that wasn't on the record that was said in chambers, which is par for the course, we agreed, Your Honor, that if Mr. DeGuerin couldn't be there, Mr. Ray, Mr. Lewis, and I could do it. We're not talking about that scenario now. Mr. Ray and I can't do it. Mr. Lewis, for his own reasons, should not do it at this point in time. I don't want to subject anybody to it. I don't want your bailiff exposed to it, your courtroom clerk. I don't want Mr. Bailey exposed to it. So I'm saying to you, Your Honor, without any authority, Mr. Lewin just grabs things out of the air, makes the same arguments he's made over and over again about our motives for things. Our motives are pure, Your Honor. Our motives are to defend Robert Durst, and our motives are to see him get a fair trial so that he can be acquitted if he should be, and the state to have a fair trial so that if he shouldn't be, he isn't. But it's not to ram this down our throats at a time. How about the idea, Your Honor, of what our state of mind will be as far as being defense lawyers, being in an environment where we're potentially subjecting ourselves to illness? Is that the kind of lawyer Mr. Durst should have? Is that the kind of lawyer anybody in California should have? It just seems to me, Your Honor, that this reaction that somehow this is like a ploy is absurd. The pandemic is real. You shut things down for a reason. It's boiling over in Cali right now. It's like a petri dish for this. It leads to death, Your Honor. And I can't understand how a district attorney, because of his own personal desire to see this case finished for whatever his reasons, and I will say the following, Your Honor, he talks about delay. The court has commented on multiple occasions that this case could have taken a month if Mr. Lewin didn't put it on the way he put it on. So with that said, Your Honor, either grant the mistrial most respectfully, Your Honor, or at least proceed to inquire as to what the status of our jurors is, even though I don't believe the case law requires you to make those findings. Thank you, Your Honor.
All right, thank you, Mr. Chesnoff. Thank you. I'm going to address some of the arguments in this way. I think the argument is very passionate on both sides. We are in a very difficult time. It's an emotional time. People are frustrated, and I'm not surprised that that might come out in argument. But I need to focus on the issue before me. Let me speak first of all to the larger issue, the health and safety concerns identified by the defense and acknowledged by the people. They're legitimate. Those are real issues. I agree. I'm completely sympathetic. And I will not put anyone's health in jeopardy. Secondly, I'd like to say that the right to counsel is as important to me as it is to the defense. And the right to counsel will not be compromised. Neither of these concerns are the issue before me now. I want to focus on the law. The standard for granting a mistrial was stated, as both sides agree, by People v. Ayala, 23 Cal 4th 225. It's only when a party's chances of receiving a fair trial have been irreparably damaged, that a mistrial must be granted. And I want to focus on one very important fact. On March 13th, the defense moved for adjournment of the trial until safety could be assured. That was the time frame that the defense sought. That's the standard they wanted me to use in determining how long this trial ought to be adjourned. The court granted the defense motion on March 16th, and the court has deferred the trial twice since then so that we could in fact assure safety to all of the participants. That does remain the court's primary concern. Here for you, safe for you, is the motto of the Los Angeles Superior Court. We are both. Justice will be done here, and it will be done safely. According to the motion, the length of the delay is unprecedented. This is not correct. The defense, on the first page of their brief, cite People versus Gray, 2005, 37 Cal 4th, 168. It permitted an 11-month delay where the adjournment was on defense motion and the jury received regular admonitions. In our case, the trial was adjourned for good cause and on defense motion until safety could be assured. The jurors were admonished again on Thursday. That's the third time in 3 months that they have been admonished. Our case is governed by Gray. The distinction suggested by the defense is a distinction without a difference. Though the delay in Gray was between the guilt and penalty phases of that trial. Capital trials are unitary proceedings. The guilt phase is an integral part of the penalty decision. The circumstances of the crime presented 11 months earlier were critical to the penalty phase decision. And our Supreme Court affirmed denial of the mistrial motion. The defense focuses, of course, on the impact on jurors. First of all, the idea of fading recollection. We have, as Mr. Lewin has pointed out, only 2 days of testimony. It can be read back to them. That's what Gray said at page 227. This is no different from any long trial. If a trial lasts for months, it may be difficult to remember the first witnesses. This is not a reason for a mistrial. It is typical in trials. Also in Gray, this argument was waived because it was adjourned on the defense motion. The defense took a writ. They knew it would delay the penalty phase. That's the path they chose. That's Gray at page 227. Interesting question is whether a mistrial is required where jurors have been given a one-sided presentation. That was People versus Engelman, 116 Cal 3rd, sub 14. And in Engelman, there was no justification for delay, and the jury had heard the entirety of the people's case before the adjournment. And this is more like People versus Katzman, 258 Cal 2nd, 777, where the delay came after jury selection, before evidence, so there is no prejudice. This case is somewhere in between, but much closer to Katzman. But Santa Maria, which the people cite, was a completely unjustified delay. There was no reason at all for the court to adjourn. And so it was a very little personal reason of the judge that wasn't justified. Here, there's ample justification. It's interesting, in gray, quote, "The decision would turn largely on evidence the jury had not yet heard." That's absolutely our case here. Though there may have been some evidence that can be read back, and everything will turn on evidence the jury has not yet heard. So this argument that the jury's only heard a one-sided presentation does not justify a mistrial. Gray distinguished United States versus Hay, and there the jury had heard all of the people's evidence before an unjustified adjournment. So our situation is governed by Gray. There is no need for a mistrial. Let's talk about exposure to media accounts. First of all, it's speculative that this is so. It's not been demonstrated. Jurors are presumed to follow their admonition. That's Gray at page 229. And our minutes fully reflect an admonition after adjournment and 3 additional admonitions over the course of 3 months. Let's talk about the likely hardship to jurors. And the defense has described what may be, what is possible for our jurors. First of all, this is speculative. And they know it's speculative. I think that's why there is a request for a questionnaire. I see why the questionnaire apparently was used and led to a mistrial. It's a very, not only a very suggestive questionnaire, it's very intrusive. I see no authority for giving a questionnaire of that nature. If jurors have hardships, when they return, they will let us know, and we will deal with them. There are many possibilities short of a mistrial. Let's talk about the risks to trial participants. In the brief, the defense describes the need for conditional witnesses as somehow justifying a mistrial. And that just doesn't follow. If the witnesses are unavailable, their recorded testimony is admissible. If they're not unavailable, it's not. It's not a justification for a mistrial. And it's the same thing with remote testimony. Either it satisfies Maryland versus Craig, 497 U.S. 850, or it doesn't. It's not a mistrial. As far as the defense counsel being their health and age precluding their travel at this time, and that's why I've allowed the appearance today by telephone, and we'll talk about how we will proceed further, but it's not a reason for a mistrial. So there's nothing about risk and I appreciate the concern of the courtroom staff. We work here every day. We've been handling a calendar. We're very careful. We require masks. We do require social distancing. We're very careful. We're often using gloves and are frequently sanitizing our hands. I don't know that it's been disproved that surfaces are a source. I think they're not as likely a source as once thought, but I think it's important to cleanse. And we do that. We're taking all the steps that we can. We're constantly looking at issues and how they can be resolved to maintain safety. If we come to the point where we believe it's not safe, we will continue with the trial. We're not going to expose people to this illness, but to the extent that we can safely do so, we will. But the point is, it's not a justification now for a mistrial. Let's talk about justification. Defense asserts in the brief that it is, quote, a desire to avoid duplicative jury selection does not outweigh defendant's constitutional rights. And very persuasively, Mr. Chesnoff cites Stanley versus Illinois, that there are higher values than speed and efficiency, and that's sure. I mean, that's self-evident. Of course that's true. That's not the question. There's been no showing that Mr. Durst's constitutional rights are implicated, have been sacrificed in any way. And it's not a matter of weighing. Mistrial is not a matter of weighing. It is a matter of justification. Have legal grounds been stated or not? They've not been stated. But let's talk about the value of having a jury. It took us 2 months, narrowing down more than 1,000 individuals down to 23 jurors. We brought in more than 100 jurors a day into our jury assembly room. We cannot do that under the current circumstances. Redoing that will take more than twice as long. So keeping our jury saves 4 to 6 months. It's enormous judicial economy. And that's real. That's 4 to 6 months where we'd be in the courtroom, where we'd be taking risks, where there would be travel and exposure. 4 to 6 months would delay Mr. Durst's speedy trial, which, though he's willing to adjourn, he said, keep in mind, he has been waiting a long time for his trial. He'd like to get it done. And 4 to 6 month delay is a real delay. It is extra courtroom time, period. The concern was that the jurors didn't know the trial would take this long. Well, but still, they're not in the court. They're not in the court for this period of time of our adjournment. So the 4 to 6 months is very significant. But again, I'm just explaining why it is so important for us to keep our jurors. Everyone has a right to the jury we have selected, and there is no speculation about those jurors is not justification for a mistrial, nor is this a weighing process when there's been no showing. So the motion is, and the defense reply brief are very, very well written. It's easy to forget. It's so persuasive, and the data about COVID is so compelling. It's easy to forget that it was the defense that requested this adjournment, and it's now the consequences of that adjournment to which they now object. A party can't move for adjournment and then demand a mistrial because their motion was granted. So I know that you...
May I interrupt for one moment?
Mr. Chesnoff, I know you did...
Correctly, and I may be wrong. We asked for it because we were afraid we were going to get sick. And everybody else had left, and I drove back from Las Vegas to ask for the adjournment because of fear of being sick. I believe at the time we indicated that we may at some point in time have to seek a mistrial. But even if we didn't, Your Honor, when we researched it and we found cases that were not in the penalty phase, but in the trial phase, where there was a break and an adjournment, and all these cases going back to the 1800s said that that kind of a break in and of itself is the basis for a mistrial.
Okay.
We had an obligation to Mr. Durst to file it.
I'm not against it. I'm not against your filing the motion. Okay, so maybe that, to be fair, when you move for an adjournment, and then when you realize the adjournment would have these other consequences, then you realize you ought to move for a mistrial. In particular, you're talking about all of these cases, none of which describe our situation, all of which are superseded by Gray. You did quote 19th century cases, and those did talk about various assumptions about people and what they would do, but they are no longer controlling. Gray is controlling.
Your Honor, most respectfully, the adjournment would have happened anyway because the courts were shut down. So
that's true, but it was on defense motion, and that it was defense motion. It governs. And
Your Honor, the court commented that the issue of the right to counsel, I'm guessing you're saying it isn't right?
that's true. That's true. It is not right.
Okay, well, okay. We believe it is because we are the ones faced with the dilemma of being asked to come back on July 27th. So my question for the court at this time is, when the court is saying you want to be assured that everything is safe, are you of the opinion now that based on the recommended courtroom and changes that it is safe for Mr. DeGuerin, Mr. Ray, and myself?
I'll get there. We're not at the point where we're scheduling our next appearance, but
All right, thank you, Your Honor.
we will discuss it. All right, so the motion for mistrial is denied. Next is the motion for two motions regarding witnesses. The first one is regarding conditional witnesses. And the people assert that those witnesses are unavailable under Evidence Code Section 244. Witnesses who are conditionally examined are identified. Do you have anything to add to your motion?
I do, Your Honor. It's very interesting. The defense is contesting the unavailability of the four witnesses, apparently completely disregarding the fact they've now stipulated to the testimony of two of them, which occurred well before they filed that motion. So we are only down to two witnesses. The other two, Silverman and Lackman, we have agreements already. So we're talking about two witnesses. Those are Shaven and Struck. And the situation, Your Honor, as the court's aware, Detective Struck had a number of health issues previous when we tried to get him out to testify at judicial examination. We are also being told, and I'm hearing this from prosecutors that I've talked to in other states, that what's going on now with respect to the interstate compact is that if you have a witness that has already testified for the purpose, they were brought out to testify, it was memorialized, etc., and now you are coming to that out-of-state court saying, hey, listen, so-and-so is a necessary witness and they have to come back out again. What these judges are saying, which makes sense, and the court would have to sign off on this as well, is in essence, given the situation with COVID, and again, Mr. Chesnoff responds, or whoever wrote that motion, responds that, well, what's the big deal? It's no different having a witness travel across the country in airports than it is having a witness or the defense themselves come in here. That's just not true, as we all are aware, and as everyone has recommended. Two places that everyone has basically said, every expert you don't want to be, are on a cruise ship and on an airplane. So the problem we're going to have, Your Honor, is even if the court rules, you know what, I'm not finding these witnesses unavailable. The problem we're going to have is my guess is going to be, particularly with Detective Struck, is we're going to have an incredibly hard time convincing a New Jersey judge when he came out here and testified over his own objection last time that he is still necessary. Now, these are issues that we brought up to the defense months ago. I brought this issue up in terms of Detective Struck, and I want to be clear. He is likely, we're not even going to call him as a witness. Mr. Durst has already said that he is going to be testifying. I will be able to cross-examine him on everything that I want, and there are statements that he's already given that are going to cover what I would likely need from Detective Struck. The defense is the one who brought him out for conditional examination. So I've told them, listen, if you want Detective Struck out here, you better go arrange to get him, because very likely we're not going to be calling him. Now, I did that. I sent a series of at least 4 emails, of which the judge you were copied on them, laying that issue out. They have not responded other than to say that we don't have a position at this time. So I think, Your Honor, that the idea, and it's within the court's, certainly its parameter, its authority right now, how on earth can the defense say, well, you haven't demonstrated unavailability for this out-of-state witness, when he's 75 years old, has pre-existing health issues, has a letter from his doctor saying that he can't travel, has a pre-existing letter from his doctor that went back to his issues regarding the conditional examination. I don't think the court, Your Honor, has to individually, at this point in time, given COVID, the court can look at the CDC recommendations, etc., and the court can make a finding that, you know what, that's why we conditionally examine these people. But again, what's ironic is that very likely he's not even going to be our witness. We're likely not even going to call him. And I told the defense, listen, I'm going to be very fair and honest with you. If you decide that you want to call Detective Struck, I'm not going to play games with you and say, well, you don't get to call him because he's not unavailable. That's not how we do things. As the court's aware, that's not how we've done things throughout this trial. We've assisted the defense numerous times in witnesses. We're the ones that arranged for Detective Struck the first time for the defense. So I think with respect to Detective Struck, that's where we stand. Now, Mr. Chavin, at this point, Your Honor, the last time that I spoke with him, he has indicated that he is willing to come out here despite the risk. I had detectives on the line on that. I've already informed counsel of this as well. I don't know if that's going to last. And quite frankly, I think we'll be in the same position. He is in his mid-70s as well. Again, testified here for several days. I think that if he decides that he does not want to come out, I don't think we're going to have much choice. Which brings as to why we need to do this now. I need the court to give a ruling on witness unavailability so at least we can edit their testimony. By the way, we sent transcripts to the defense, as we've done with everything, and we said to them, listen, if you can, you're off for months. Please go through this, and by going through it, you're not agreeing that they're unavailable. But if you don't do it, we're not going to have the time to be able to edit it, and we cannot be in a position where we interrupt the trial because we have to edit 2 or 3 days of testimony. So, Your Honor, bottom line is, witness unavailability pursuant to 240 has been shown, particularly with the context of COVID and the instructions from the Chief Justice of the Supreme Court. With that, it would be submitted.
Mr. Chesnoff, will you argue this as well?
Mr. DeGuerin is going to respond, Your Honor. Thank you for asking me, but I believe Mr. DeGuerin is going to respond.
All right, Mr. DeGuerin, you may proceed.
Thank you, Your Honor. I see that it's really the prosecution's motion. I see it as a very narrow issue, and that is whether the court would judicially legislate a change in what 240 requires as to unavailability. Simply, what they propose about these witnesses does not comply with what's required to show unavailability. Under Rule 240, we say that it's a very narrow issue, and that the COVID-19 threat does not fit what 240 requires. I know that there is the same conundrum, apparently, that Mr. Lewin sees, and that is they want to start the trial right away, regardless of whether I'm available or Mr. Chesnoff is available or Mr. Ray is available because of the COVID-19 threat, which is a business health threat. It's not the same health threat that we had before at all. Because they want to start it without our ability to be there, and yet they say that it qualifies that the witnesses are unavailable. So either everybody's unavailable or nobody is.
All right, thank you, Mr. DeGuerin. Is that it? You have anything else?
Is it that everybody's unavailable under these circumstances?
Thank you, Mr. DeGuerin. And do you wish to reply or you submit it?
Submit.
All right, so infirmity is one of the bases for unavailability under 240. That is 240A3, dead or unable to attend or testify at the hearing because of then existing physical or mental illness or infirmity. And I think the briefs seem to go on a different tack. I think the case law, in fact, it talks about mental infirmity, but that doesn't mean that physical infirmity doesn't qualify. I found a case of physical infirmity, Hernandez, People versus Hernandez, 263 Calap 2nd, 242. So vulnerability to illness is infirmity. It's not a matter of simple fear. It's not mental infirmity. It doesn't require expert testimony, despite the brief. 240C is a section that describes expert testimony for certain circumstances. This is 240A3, physical infirmity. The court has discretion as to the sufficiency of the showing. People versus Alcala, 4 Cal 4th 742. And at this point, I agree. CDC guidelines specify persons age 65 or older or with serious medical condition should stay home. So the vulnerability to COVID-19 due to age or health is infirmity. The people have made other showings as well. So the conditional examinations, I guess Lockman and Silverman aren't an issue, but also Nick Chavin and Detective Michael Struck will be admitted. And that is, of course, unless there's a dramatic change of circumstances. It's been established that they are unavailable.
With respect to that issue then,
Yes.
can the court order, obviously we're going to be using Mr. Chavin, we're going to get his stuff ready. If he's able to come out and he's willing, then,
That's better.
Then we'll do it. However, we need the defense, Your Honor. Can the court order the defense to cooperate on, we've given them a transcript of Detective Struck. Now that the court's made that order, we need to edit it. Whether or not the defense is going to use him or we are, it's highly unlikely we're going to use him, but we don't want to be in a situation of ineffective assistance where the defense ends up saying later, oh, we didn't have time, now all of a sudden we need to use Detective Struck's transcript and we're not ready. Now we will volunteer, Your Honor, at great expense and time, if once we get an agreement from the defense of what Detective Struck's testimony would look like, we will assume the responsibility, even though we are unlikely to call him as our witness, we will assume the responsibility of doing the editing. That is something that we don't need to do, but we'll do it.
You've reached a number of stipulations. I'll get to that a little later.
Okay.
And that shows how you can cooperate. I'm sure that you'll cooperate. I don't think I need to order the defense to do anything, but since they have this time on their hands, I'm not going to delay to have it accomplished if it can be done now. Well, let's talk.
To that, Judge.
Is that all right?
One of the problems has been the suggested redactions in the transcripts that we've been provided have what's been redacted blacked out, so we can't see what's been redacted. In other cases, other witnesses, there's simply a line through so we can see what's been redacted and either agree or not agree. If I would get Mr. Bailey, and I think Mr. Bailey's the one that's doing it, whoever, if we get them to change the way.
No problem, Mr. DeGuerin. We'll give you a blank copy of Struck. You just highlight what you want in, and then we can go from there and talk about it.
All right, thank you, Mr. Bailey. That was Mr. Bailey, and that didn't need to be on the record, but it is on the record. Mr. Bailey described exactly how the cooperation can be accomplished. Thank you.
We're concerned he's being held hostage, Your Honor. We don't see him physically. He's on their call. If the court could inquire as to his current safety.
Mr. Bailey,
So he isn't.
are you on a mountain somewhere, Mr. Bailey? You climbing a mountain, Mr. Bailey?
I'm in Yosemite Falls right now. I'm in Yosemite, looking at Yosemite Falls. It's gorgeous.
We're very jealous, Mr. Bailey. Thanks a lot. Okay, next, let's talk about remote testimony. So this is a motion to allow certain witnesses to testify, and this motion uses Penal Code Section 1340 as a model and relies on the Code of Civil Procedure. Oh, do you need a break? We need to take a break, and then we'll launch into the issue of remote testimony. So we'll see you back at 11:45. All right. Recess.
You want me to call you back on this line in 10 minutes?
How about if everybody from the defense just calls back in 10 minutes? Is that okay?
That's fine.
Don't forget Mr. Bailey and Please maintain social distancing
That's
when
fine, thank
exiting the courtroom. Thank you.
I'm sorry, what are we doing?
You're maintaining
Back
some...
in 10 minutes, I mean.
Yeah.
We're calling back in 10 minutes? Yes. We're taking a recess.
Same call-in number, Dick? Yeah.